Good morning, everyone. I'm Jane Fielding, and I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK. And I'm delighted to welcome you to this, the third of our annual webinar series. Unfortunately, we had to cancel Tuesday's webinar due to a bereavement in the team, and I wasn't able to deliver that webinar, but we will be rescheduling it for later in the month. So do please look out for that. So today's topic is settlement agreements on exit. And those can obviously be a very useful tool to achieve a clean break with the employee exiting with agreed terms. Everybody knows where they stand. But as employers are almost always the party that drafts the settlement agreement, it can be a little bit of an own goal if you get something wrong in the drafting. So we thought it would be timely to give you some tips on common pitfalls that we see in the settlement agreements that come across our desk, and give you a bit of a refresher on what not to do and what to get right. So our speaker today is Jasmine Coyne. She's an associate in the team, and she has a broad practice, but a part of her daily diet, I would say, probably is helping employers navigate settlement agreements and getting them signed off to protect the organisation. So Jasmine is going to talk for 30 minutes or so. As usual, we'll leave some time at the end for questions. If you want to ask a question, then please can you use the Q&A function. You'll find it, as you probably all know by now, in the bottom middle of your Zoom screen. If you could please leave your name, because if we don't get to all the questions, we do commit to come back to you separately by email afterwards. And obviously, if you ask it anonymously, we won't be able to do that. If you've got any technical issues as the webinar goes along, hopefully you won't, but if you do, again, please use the Q&A function. And Lucy Strong, who's helping us behind the scenes make this all work, will come back to you and try and sort it out for you. And at the end, we will circulate a questionnaire by email. I'll flag it again before we finish, but if you could take a couple of minutes just to fill that in and send it back to us, we would really appreciate it. We do use your feedback to help work out what to do in future sessions to make sure we're covering topics of interest to you. So I will turn my camera and microphone off and hand over to Jasmine.
Thanks, Jane. Welcome everyone to today's webinar. It's often easy, I think, when preparing settlement agreements, just to dig out the last one that you did and start from there, and not properly consider the contents of the agreement itself. So the goal of today really is to highlight areas of and issues with settlement agreements that we might overlook. So just starting in terms of a broad overview of what I want to talk about today, I want to talk about the limitations of settlement agreements and the sorts of claims that can't be waived, particularly in light of recent case law, and with this in mind, how employers can manage their risk. And I expect that will take the majority of the time today. But I also want to touch on how to provide effective consideration for the other obligations set out in the agreement. We'll go on to discuss confidentiality clauses and their limits. I'll run through a tax treatment of termination payments, and particularly those payments that don't appear in every agreement. And to wrap it up, we'll run through some practical tips for issues surrounding settlement discussions. So as Jane said, really, after employment contracts, settlement agreements are one of the most common contracts that come across our desks, and probably yours too when dealing with employees. And they can be entered into at any stage of the employment relationship, but most commonly we'll see them on exit. And really we're using them because employers are looking to tidy up what's gone before in the employment relationship. And on the case of an exit, to have a clean break from that particular employee with no repercussions from their employment. There are, however, limits to settlement agreements, and as a reminder, there are some claims that can't be waived, and I've put a few on the slide here, but I should say not an exhaustive list. So settlement agreements can't be used to waive statutory payments such as maternity, paternity, adoption pay, or shared parental pay. And we have the case of campus living villages, which gives us some helpful guidance in this area. So this was a case that came before the tax tribunal rather than the employment tribunal. and involved an employee who was dismissed by reason of redundancy while she was pregnant. She later brought a claim for unfair dismissal and pregnancy discrimination, which was compromised by way of a COT3 agreement. So in other words, settled by ACAS rather than under a regular settlement agreement. But the employer agreed to pay £60,000 in full and final settlement of all of the claims arising from contracts, and also an injury to feelings payment of £20,000. But on review, the tax tribunal found that the Social Security and Benefits Act provides an absolute right to statutory maternity pay. So any agreement which purports to contract out of that right is void. So if you're in a situation where you're looking to settle claims with an employee that has a right to a statutory payment like maternity pay or paternity pay, it's really important that you make sure that entitlement is clearly specified and accounted for in the settlement terms. Another hot topic is data protection, and we get asked whether employers can settle or use settlement agreements to ask the individual to waive their rights under data protection legislation. But the Data Protection Act contains no specific provisions that permit individuals to contract out of their rights under the Act. So including a provision on the part of the employee not to make a future data subject access request, whilst a provision like that might deter the individual from making a future DSAR, given the lack of a relevant exemption in the legislation, a provision like that is likely to be unenforceable. So if the employer sought to rely on the terms of the settlement agreement by not responding to the DSAR, they'd likely be in breach of their data protection obligations. So do make sure, if you do plan to use or include a provision like this in your settlement agreements, you only include them on the basis that limitation is understood. We also get asked in relation to data protection whether we can require the employee to withdraw an existing DSAR under the terms of the settlement agreement, because it is relatively common for a DSAR to be made by an employee or a former employee in the context of a workplace dispute, whether that's to flush out relevant evidence or just to put pressure on the employer. And in this context, I think a clause requiring the employee to withdraw or not pursue an existing DSAR is likely to be acceptable, because particularly in circumstances where the individual is receiving independent legal advice on the terms and the effects of the agreement. From the next 2 bullet points on the slide, I also want to highlight that purporting to settle any failure to inform and consult claims, either because the obligation arose in a collective redundancy situation or in the event of a TP transfer, will also be void if settled under a settlement agreement, because these are claims that can only be settled via ACAS conciliation and reaching agreement under a COT3. So what we've touched upon so far has been the status quo for quite a while. So hopefully should just be a refresher really, rather than shifting the way you look at settlement agreements altogether. But the last point on the slide, future claims, is relatively new, and we'll take a look at that in more detail on the next slide. So section 147 of the Equality Act, which allows employment discrimination claims to be compromised by way of a settlement agreement, requires, amongst other things, that a valid settlement agreement must be in writing and must relate to the particular complaint. And there's been a lot of debate over the years about the meaning of must relate to the particular complaint and the ability to settle potential future claims. In October 2022, this issue came before the Employment Appeals Tribunal sitting in Scotland. And as a reminder, the EAT in Scotland is binding on tribunals in England and Wales as well. And it appeared in the case of Backgate, and the EAT in Scotland held that relates to the particular complaint does not allow for settlement of a future claim unknown to the employee at the time the agreement was concluded, because the EAT considered that Parliament's intention when enacting section 147 of the Equality Act was that it should only be available in respect of complaints that have already arisen between the parties. So in other words, settlement can only be of either an existing actual complaint or where the grounds of complaint existed when settling. And you might ask, where does that leave employers who want peace of mind and certainty about future claims? Well, I think there's been a long-standing practice when drafting settlement agreements to draft them in wide catch-all terms to include future claims as well. But the impact of the Bathgate judgment is that general waivers won't work for future claims. As a matter of practice at Gowling, we've decided not to change our precedent settlement agreement at this stage because our current drafting tries to highlight and mitigate the risk of future claims in a number of ways, which you might also consider adopting. So, for example, we split out the claims into two categories. The first category being claims that have actually been asserted by the employee or likely to exist from the facts of the situation. And then a second category of other claims that could exist given the wider circumstances of the employee. And we recommend that when listing the waivers in your settlement agreement, you only include those waivers that could potentially exist for that employee. So we'd recommend deleting anything, for example, to do with part-time working if the employee you're dealing with is always work full-time. And after we split out the waivers into categories, we then back up that categorization of waivers in the warranty clause as well. We do still take the approach of including wording about settling future claims in the agreements, but in practice, really, if you're settling with an existing employee who's brought a claim but isn't leaving the business, it isn't really reasonable to settle future claims anyway. And if the employee is leaving, the potential for future claims is generally very limited anyway. And keep in mind that it is worth including the wording on future claims in your agreement just for deterrent effect, if nothing else. In terms of how employers can minimise the risk of future claims being brought, it may be appropriate to include a warranty from the employee confirming that the claims listed in the agreement are the only claims that they have, and a statement to say that the employer has relied on the warranty when entering into the agreement. Depending on the circumstances, it may also be appropriate to include a provision entitling the employer to withhold part of the termination payment for at least 3 months and only pay the remaining part of the payment if the employee hasn't brought any claims against the employer. It's also important, particularly where the employee signs the agreement prior to the end of their employment, that steps are taken to minimise the possibility of a cause of action arising that they could then bring a claim for. And this could be achieved by either minimising the time between signing the agreement and the termination of their employment, or if that's not possible, placing the employee on garden leave the remainder of their employment so that their contact with others is minimal. And you might also consider requiring the employee to sign a reaffirmation letter where there's a gap between signing the settlement agreement and the termination of employment. And in that case, the employee would reaffirm their waiver of claims as at the date of termination. So hopefully you can see that, particularly in light of the Bathgate judgment, that it's really important that when you are drafting the settlement agreements, you give thought to minimising the chance of future claims arising and being brought when preparing and issuing the settlement agreements. So moving on to the wider terms of settlement agreements, apart from reflecting the main bargain being the waiver of claims, settlement agreements often contain other typical clauses such as confidentiality clauses, non-disparagement obligations, and in some cases, post-termination restrictions. In return for the waiver of claims, employers tend to compensate the employee with money or offer a reference, for example, and it's, I think, easy sometimes to assume that valuable consideration is being provided for the rest of the obligations in the agreement. And we often see employers step up in this area. So what I want to highlight really is just to make sure that each obligation in your agreement has valuable consideration being provided for it, unless the agreement's being executed by deed. In terms of confidentiality, for example, if the obligation to keep the agreement confidential is made mutual, in other words, it applies to both parties, the question of what consideration the employee is receiving shouldn't really arise, because the exchange of those promises should be sufficient. But if the obligation is one way, such that only the employee is bound to confidentiality, then it's advisable to allocate specific consideration amongst the total termination payment for the confidentiality obligation itself. And that's because HMRC has been known to argue that income tax should be paid on consideration for requirements to keep the terms of the settlement itself confidential. So taking the step of specifying a realistic sum as consideration for confidentiality duty should reduce the scope of arguments with HMRC, which I think everyone wants to avoid. The same principle is applicable to one-sided and mutual non-disparagement obligations. So again, do make sure that they're either mutual obligations or specific consideration is allocated. And in the case of restrictive covenants entered into on or after termination of employment, they also need to have a payment allocated as consideration in order to ensure that they're binding and enforceable by means of an injunction if the settlement agreement is to be executed as a simple contract. Although saying that, as always, with post-termination restrictions, enforceability is also going to depend on the restrictions going no further than is necessary to protect a legitimate business interest. We do see on occasion, though, a desire by employers to introduce new post-termination restrictions without consideration where the contract is being executed by a deed. But an employer's ability to do that really depends on the bargaining position between the parties. So it might be up to you to manage the expectations of the other stakeholders who I want to be pushy about the restrictions to be included without being willing to offer additional compensation. And this is something that might be difficult to achieve if the employer's bargaining position isn't a particularly strong one. On this slide, well, we've touched on confidentiality already, but I just want to run through the limitations of the confidentiality clause. They are a recurrent feature in settlement agreements, as it is normally in both parties' interests for the terms of the settlement to remain confidential. And an express term is often included to that effect. And these days, confidentiality clauses are often referred to as non-disclosure agreements or NDAs. And we'd normally expect settlement agreements to limit the employee from discussing the terms and existence of the agreement and the circumstances leading to the settlement, save for that they may be permitted to disclose information to certain specified categories of people, for example, their spouses or immediate family members. If there's a mutual confidentiality clause in the agreement, the company will make a promise that its officers and employees similarly will also not disclose the circumstances giving rise to the existence of the settlement agreement. And as a reminder, if you do, as a matter of practice, include a mutual confidentiality clause on the part of the company, make sure that that limitation only extends to employees and officers directly involved in the preparation of the agreement, because practically it will be very difficult for the company to manage more than a handful of people. So go back and check your own agreements to make sure that you're not making promises that it will be difficult to keep practically. The next section of confidentiality clauses is usually a carve out from the general confidentiality obligation, which says that disclosure of the circumstances leading to the agreement and the agreement itself may be discussed in specific circumstances. And in 2018, the Solicitors Regulatory Authority published a warning notice to solicitors on the use of NDAs. And the warning notice reminds us that NDAs shouldn't be used as a means of preventing or seeking to deter a person from reporting wrongdoing or cooperating with a criminal investigation or prosecution, reporting misconduct to a regulator, or making a protected disclosure under whistleblowing legislation. So hopefully you're already including these carve-outs in your agreements, particularly in relation to protected disclosures, because you can't contract out of whistleblowing legislation. But in case you missed it, there's also been updated guidance by the Law Society to state that NDAs, well, in the case of NDAs, it would be unusual to prohibit disclosures to professionals, for example, for medical or therapeutic reasons, on the basis that in most circumstances, qualified medical professionals are subject to a duty of confidentiality anyway. The government has weighed in on this a little bit and has indicated that when it comes to medical professions, therapists and counsellors wouldn't necessarily fall within this exception, as they're not regulated professionals with strict use of confidentiality. But keep in mind that some categories of therapists can voluntarily join a register to become professionally accredited and are then bound to observe a duty of confidentiality. So when you're reviewing your confidentiality carve-outs, we'd recommend that for the time being, when including an exemption for medical professionals, the extent that that applies to therapists and counsellors, make sure that that's limited to those that are subject to professional duties of confidentiality. And also when it comes to the carve-outs, make sure that the confidentiality clause is appropriate for the particular context of the individual case. And I should say that the SRA warning notice is directed at anyone who is regulated by the SRA and highlights that issues such as inappropriate use of NDAs or failing to report misconduct that is the subject of an NDA may put practitioners in breach of SRA principles. Over recent years, the hashtag #MeToo campaigns highlighted situations where NDAs or confidentiality clauses in settlement agreements in employment context have been used inappropriately as a way of deterring individuals from reporting instances of sexual harassment and abuse. So this has really prompted increased scrutiny around the use of NDAs and in turn highlighted the potential repercussions for practitioners involved in advising on those types of clauses. So it really is one to get right and take seriously. As a result as well, in terms of horizon spotting, the government has a lot of pressure on it to act and legislate against the unscrupulous use of confidentiality clauses in discrimination and harassment cases, but also more widely. So there may be more coming down the tracks in this area. Moving on to our next topic, one perhaps that many would rather not think about often, and that's tax. And full disclosure, my specialism is employment law and not tax law, but when handling settlement agreements, it's something that we need to grapple with every time. So it's necessary to have a good grasp of the basics. And the basics tend to be that payments in lieu of notice, holiday pay and bonus payments are taxable, and compensation payments are paid tax-free up to £30,000 under the exemption set out in the Income Tax, Earnings and Pensions Act, ITAPA. And where it goes past those standard payments that you deal with regularly, it's at least important to be alive to the fact that there could be tax implications on other payments at that stage, that it may just be necessary to get more advice. So on the slide, I've listed common areas where employers can get in a twist over tax. The first is on continuing benefits. It's not uncommon for some employees to request that certain benefits continue after their employment ends, mobile phones, access to healthcare. And in this area, there's firstly a practical point to keep in mind, and we'd recommend that you don't commit to offering a continued benefit after the termination of employment unless you know that the provider is willing to do that as well. So either check with your provider first before agreeing, or make the benefit conditional upon the approval of the provider. And secondly, it's important to keep in mind that a benefit like this is also likely to be taxable and should be highlighted in the settlement discussions to the employee. The next point I want to flag is a point that's been around for a while, and that's payments in lieu of notice, which are now all subject to tax up to a notional amount called post-employment notice pay, which is calculated using a specific formula under ITEPA. And the tax rules apply where there's been a termination and then a payment. There was previously a distinction between payments made as a contractual payment in lieu of notice, which were fully taxable, and payments that weren't contractual. But that distinction is now gone, and the aim of the legislation is to tax as earnings the basic pay the employee would have earned had the employee worked their notice period, even where there's no contractual right to a payment in lieu of notice. So once you've calculated the post-employment notice pay figure, you need to compare that to the actual payment that's paid on termination. If the actual termination payment is equal to or less than the post-employment notice pay, the whole amount is treated as earnings and be fully taxable. Whereas if the termination payment is more than the post-employment notice pay figure, then the amount equal to the post-employment notice pay figure is treated as earnings and is taxed, and the balance will then fall within the £30,000 exemption under ITEPA. Another easy area to forget is redundancy payments, which, provided they're not taxable as post-employment notice pay, fall within the £30,000 tax exemption. But it's important to remember that you only get one £30,000 tax exemption in relation to each termination of employment. So this means that any payments that fall within that £30,000 tax threshold must be aggregated. And it's particularly important to remember and easy to forget where the employee was made redundant several months ago, received a large redundancy payment, and subsequently brings a claim. Because when you come to settle that claim and make a termination payment, it may be that the employee has used up some or potentially all of their £30,000 tax exemption already. So that's just something to keep track of and keep in mind. Also, in settlement negotiations, you may be asked to apportion some of the overall settlement payment to injury to feelings. I know that not all employers will want to do this because it might seem like an admission of wrongdoing, but nevertheless, it's sometimes what's agreed. But if an injury to feelings payment is being made, you'll need to assess whether that injury to feelings payment arises from discrimination during the employment or discrimination connected with the termination itself. Because if the payment relates to injury to feelings and the discrimination giving rise to the payment isn't related to the termination of employment, it can be free of income tax. If the payment compensates for financial loss and the discrimination giving rise to the payment is not related to the termination of employment, the payment isn't a termination payment, but might still be taxed as earnings, and compensation for loss of employment where the cause of the termination is discrimination, or where discrimination occurs in the process of termination, is caught by the ITEPA £30,000 tax exemption threshold. So really, when assessing the injury to feelings payment that you're making, you need to be honest with yourself and the business as to what the injury to feelings payment relates to, because it might be tempting, because some injury to feelings payments can be paid tax-free, to pin down the injury to feelings payment in a particular area. But you should avoid doing that and be honest with yourselves and the business. You should also refer to the benefit guidelines to assess what you think the likely award for an injury to feelings payment would be if the employee's claim came before an employment tribunal. And for those that aren't familiar with the benefit guidelines, they stem from a Court of Appeal case, which sets out 3 bands of awards for injury to feelings. and they can be categorized as lower, middle, or upper band. So just because an injury to feelings payment might have a favourable tax treatment, you need to avoid apportioning any greater amount to that injury to feelings payment than would be awarded by the tribunal. Now, I appreciate that's a lot to take in on tax, and you'll probably be relieved to hear that that's the end of the tax portion of the webinar. But on the last slide, I promise it's less technical because it contains some practical tips. So yes, I just want to finish with practical steps that should be taken when entering settlement discussions. If the settlement agreement is targeted at an employee who may be in line for dismissal, it's easy, I think, to get caught up in negotiating the settlement, and you can call the employee into a meeting, tell them that it's not going well and that you'd like them to leave, but that you'll be offering them a settlement agreement. You then send the employee out the door with a draft settlement agreement ready for discussion with their lawyer. But have you given them notice? And the answer is not necessarily, because provision of an unsigned settlement agreement won't constitute written notice of the termination of employment. So this is particularly important to keep in mind if negotiations become protracted. If you've not given notice to terminate, when you intend to, you could end up handing over more money in respect of normal pay and then notice pay than you perhaps anticipated paying by the time the agreement's been signed. So as well as providing the settlement agreement, if the employment is going to terminate, make sure that you provide effective notice in accordance with their contract, and don't just rely on providing them with a draft settlement agreement. And finally, though it might seem a bit noddy, just make sure that you might find it useful to make a list of who's going to perform all of the tasks set out in the settlement agreement, because you don't want to be in breach of the agreement. And it might be that you need to keep track of timings of payments, particularly if any of the payments are going to be deferred, which could become a more common practice because of the limitations of settlement agreements to settle future claims. So it's good to keep track of those. It's good to keep track of timings for drop-off or collection of company property, so nothing goes missing. There may be further obligations, particularly if the employee is remaining in the business, that you need to have in mind. For example, if there's been an allegation of discrimination and one of the obligations in the agreement is to provide managers with training, you need to make sure that training happens. Similarly, if there's been an incident of disability discrimination and the employee needs adjustments which have been agreed on in the settlement agreement, you need to make sure that that happens at a local level when they return to their teams. Okay, everyone, that completes what was, I suppose, a whistle-stop tour of the areas where employers may fall down with settlement agreements and things for employers to keep in mind. And I hope that if nothing else, when you're involved in your next agreement, you stop and think and just consider whether the agreement is doing what it really should be doing. And on that note, I'll hand you back to Jane.
Thanks, Jasmine. Certainly plenty of food for thought and plenty of questions coming in all the way through as you were speaking. So as I said earlier, we'll do our best to pick up as many of those as we can before we finish. First one, Jasmine, and it goes back to the point you were talking about sort of early in the webinar about what can actually be settled. And it's, do employees need to be aware of the potential claims that they're being asked to settle at the point of signing the settlement agreement?
That's a good question. There's been a recent Court of Appeal case in this area, and to an extent the answer really depends on the specific wording of the settlement agreement. But the case I'm thinking of is Arbonescu, and in this case the employee entered into a COT3 agreement, and the purpose of the COT3 was to settle claims connected with the employee's employment that existed at the date the COT3 was entered into, whether or not they were known to the employee at that particular date. And in this case, the claimant raised allegations of discrimination against the employer, and after the termination of his employment, sought a job at another group company and was subsequently unsuccessful in securing that job. And Arvanescu alleged that his former employer had notified the other group company to reject his application because of his previous employment history with them, and was claimed for victimization against his old employer. But in this particular case, what was crucial was that the potential act of victimization complained of occurred before the settlement agreement was signed, and so was caught by the COT3. And so this is really authority for the fact that the employee doesn't need to know about the cause of action at the time the agreement was entered into.
Okay. So the next one, I think you did touch on this partly, but the question is, when is it appropriate to use a reaffirmation letter?
Yes, I think we touched on this. So we'd use a reaffirmation letter really depending on the gap between signing the agreement and the termination date. So quite often we might see a gap of a day or so, in which case you probably don't need to go through the process of having a reaffirmation letter. But the advantage of having a reaffirmation letter is that you know that an employee is going to exit at some point in the future. You want certainty of what those terms will be, and you can negotiate the settlement agreement and then do the reaffirmation at termination. So anything that's arisen between the date of the agreement and the termination date is covered in terms of waiving claims, and that already stems from the fact that there's always been a concern over the ability of settlement agreements to waive future claims. And the advantage of the reaffirmation letter is that you know that everything in the employment period is covered off. Well, I appreciate that clients might be reluctant as well to go down the reaffirmation route, just because it potentially adds to costs, but just because the employee needs to get two sets of legal advice. But I think the Bathgate case highlights the fact that actually, given the uncertainty around future claims, that using reaffirmation letters where there is a gap could become really key.
Okay. Slightly different topic and something that we didn't cover. Are there any special considerations for organisations in the public sector when coming to settlement agreements?
Yes, I suspect there will be governance concerns, but those would vary depending on the type of public sector body that the employee is in. But there'll definitely be additional concerns to make sure that the settlement represents good value for money, because ultimately the money that's being spent on the termination payment is going to be public money. I'm also aware that in terms of civil service organisations and their arm's length bodies, they have to keep in mind Cabinet Office guidance when it comes to settlement agreements and confidentiality clauses and severance payments. And they set out specific wording in relation to those clauses, and any deviation requires ministerial approval, which could lead to delay, which you will need to factor in if you're in the public sector.
Yeah, okay, so some different considerations there. We've got 5 minutes or so left. We've got quite a lot of questions as we just whiz through a few of those quickly. So there is one about NDAs, but I think we've covered that off. There's a question: are settlement agreements unenforceable if the employer doesn't offer the employee money to get the independent advice? And well, shall I answer that one, Jasmine? The answer is they're not unenforceable, but you're very unlikely to get the employee to sign up unless you agree to cover that independent legal advice, because it's you as the employer that benefits from it being a settlement agreement as opposed to just an exchange of letters or a COT3, because an exchange of letters won't settle the statutory claims, which is for most employees what you're really worried about. So legally, it doesn't say in any of the legislation you have to pay it, but as a matter of practice, you will. There's a couple of questions going back to the sort of detail of the confidentiality restrictions. So one talks about on confidentiality or non-disparagement obligations. Is it possible to include a mutual obligation clause to avoid having to allocate consideration? I think you touched on that, didn't you, Jasmine?
Yeah, so you'll either need to, if it's one-sided, attribute consideration to it, or make it mutual on the side of the company as well.
Yeah. And there's a related question around, well, if you're going to give monetary consideration for confidentiality, are we saying the payment itself should be broken down into the different elements so it would be clear if HMRC tried to challenge that? I think the answer is yes.
Yes.
Yeah. Okay. There's an interesting one here, which I have to say that we haven't talked about in the team really, but it says the 30,000 tax-free amount for redundancy has remained the same for decades. Will it be increased? Well, I'll share my view and then you can share your view, Jasmine. I think you're right. If you ever asked the question, it hasn't been increased for a very long time. In fact, I can't remember when it was last increased, but there's certainly nothing I've seen about that level being increased. And with the economy where it is, I would have thought the interest of the government at the moment would be to keep it where it is, to maximise tax revenue. I don't know if you feel differently, Jasmine.
No, I don't. I mean, you've covered it off well, Jane.
Yeah, interesting one. Thank you. And there's a question about sort of what practice we're seeing, whether we're, and this is on COT3, so ACAS conciliated COT3 agreements rather than settlement agreements that you've been talking about, but are we seeing an increase in employer initiated early conciliation? The comment is, I can see the benefit of that approach where pushing the employee into the hands of a lawyer is the last thing you want to do. I see the sense of that comment, but in terms of practice, I don't think we are seeing employer initiated early conciliation step up. People are much more likely to use the settlement agreement route with the protected pre-termination of employment protected conversation. I think you, Jasmine, do you agree with that?
Either.
Yeah, but it's a correct comment. Once you send them to a lawyer, then obviously they're going to perhaps be a little better informed in many cases than they were beforehand. And just one final one before we close. When an employee requests to exit via settlement, so the employee is actually asking to go and have it rounded off, can the employer refuse to pay a compensation payment and only offer notice and a reference? To which, do you want to pick it up?
I was just about to say, it depends on what the employee wants, but you can certainly start from that position.
Yeah, it's going to be a negotiation, isn't it? And what's the strength of the relative bargaining powers? But of course, bear in mind, if you are going to give a reference as the employer, you've got an obligation not to provide a reference that is going to be misleading to future employers, or you could be on the end of a claim for negligent misstatement. So for negligence, basically, it's that sort of not passing on a bad apple idea. And obviously in financial services there are regulations around what you have to say on references, but it's always something to be mindful of when you're agreeing to a reference. Often it's just dates of employment and role. Okay, well, thank you for all the questions, and thank you very much to Jasmine for talking us through all of those pitfalls. As I mentioned earlier, once we've finished, you will get by email a questionnaire. It only takes a couple of minutes to fill it in. Please do find the time to do that if you can, and we will take that into account in shaping future topics. Otherwise, I will let you know in due course the date for the final webinar in the series, probably later this month. But otherwise, thank you very much for joining. Thank you to Jasmine, thank you to Lucy, and have a good rest of the day.
Thank you.